Welcome to the first of 3 modules on searching international law sources. At the conclusion of these 3 modules, you will be able to identify and distinguish different international law sources and apply your knowledge to search for resources that are appropriate to your task. It is recommended that you review these modules in sequential order. The first module is a general introduction to international law sources, terminology used, and a general background to international law. International law is a general term that is often used to describe public international law, private international law, comparative law, international business law, as well as other areas of law. Before you begin researching international law, it is important to know the difference between public and private international law and comparative law, at the very least. So public international law governs the relations between different nations, international organizations, and sometimes individuals. Examples of public international law includes international environmental law, international human rights, international criminal law, airspace law, law of the sea, law of armed conflict, trade and development. In contrast to that comes private international law, which is a body of rules that is used to resolve legal disputes between private individuals who cross international boundaries. It is also referred to as conflict of laws because it refers to a dispute between one or two parties in different countries with different legal systems. Private international law helps a court determine which country's substantive law should be used to decide the matter. Although part of international law, it is in fact a body of domestic law, and each country has its own set of private international laws. Common issues that form a part of international private law are divorce law, succession law, contract law, recognition of judgments, and bankruptcy. Although private international law is a domestic body of law, a lot of work has been done by various international bodies to try to harmonize private international laws around the world. This harmonization effort is designed to minimize the impact of international legal disputes, and in so doing to promote international trade and commerce. Different again is comparative law, which is the study of the similarities and differences between the laws of 2 or more countries, or between 2 or more legal systems. Comparative law is not itself a system of law or a body of rules, but rather a method or approach to legal inquiry. Looking to sources of public international law, the classic list of international law sources are stated in Article 38 of the Statute of International Court of Justice, which has been adopted by nearly every country in the world as members of the United Nations. If you don't already know, the International Court of Justice is the principal judicial organ of the United Nations, and its decisions tend to be followed by other international courts. Its decisions, therefore, have great influence for international legal scholars and jurists. The court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply international conventions, whether general or particular, establishing rules expressly recognized by the contesting states, international custom as evidence of a general practice and accepted as law, the general principles of law recognized by different nations, and subject to the provisions of Article 59, judicial decisions and teachings of the most highly qualified publicists of the various nations, as a subsidiary means for the determination of rules of law. Although there is no formal hierarchy among these 4 sources, in practice the order of importance is generally accepted as international conventions being first, customary international law second, principles of law third, and previous decisions and scholarly works as fourth. Considering each of these 4 sources of international law in turn, and some of the terminology relating to each will assist you with your legal research. Firstly is international conventions. These are agreements between states. The term international convention is used interchangeably with other terms such as international treaty, international agreement, compact, charter, or contract between nations. Nations are often referred to in international law as states. International conventions or treaties are binding instruments governed by international law. They are defined as an instrument, an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, and whatever its particular designation. In fact, international organizations can also enter into treaty agreements in accordance with the Vienna Convention on the Law of Treaties between States. And international organizations can enter into agreements with other international organizations as well as with states. There are different kinds of treaties. These include bilateral treaties, which are between two parties and can also be referred to as an arrangement. Multilateral treaties has multiple parties. The difference between multilateral and bilateral treaties is in the legal implications. So if one of the parties breaches their obligations in a bilateral treaty, a breach can lead to one of the parties terminating that treaty. In a multilateral treaty, a breach between two parties may change the status of the legal obligations, but the treaty would remain in force between all the parties who are not in dispute with one another. Some terms that also assist you to conduct legal research include signatories. So these are the states who have signed the treaty. States that enter a treaty that was already in force are said to have acceded to that treaty. Ratification comes after signing, so that involves the adoption or enactment, which begins the legal obligation between the signatory states. Some states may make a formal declaration that upon signing the treaty, it's conditional on the modification or amendment of one or more of the provisions of the treaty. These are referred to as reservations. Entry into force is the date the treaty becomes operational. Sometimes these treaties require a certain number of ratifications before they enter into force. Having that entry into force date is quite key when you're doing legal research, and being able to find that date to enable you to correctly cite the treaty. Signature and ratification need to be translated into domestic laws before they actually create rights and obligations for the individuals living in a particular country. Treaty law is nevertheless a legitimate and important influence on domestic law. In Australia, it can be used to interpret the statutes within Australia. So when a statute or piece of legislation is ambiguous, that ambiguity can be resolved by adopting an interpretation that is consistent with Australia's international legal obligations. International custom is an interesting one. So this is the second source of international law. It's also referred to as customary law, and it's the law which has evolved from the practice and custom of states. There are two components to customary international law. There's the objective part, which is the evidence of a consistent practice amongst the states. And then there's also a subjective part, which requires analysis of whether a state has acted in a certain way because they believed that they were bound by a legal obligation. The third source of international law, international public law, these general principles of law are those principles that are common to all major legal systems in the world. They're often used to interpret the administration of justice or rules of procedural fairness when there is no applicable treaty or accepted customary international law. After general principles of law, there's previous decisions, judicial decisions, and teachings of publicists. So international courts and tribunals were created to resolve peacefully disputes over alleged treaty transgressions between member states who have signed the treaty. Their decisions can be referred to as a source of international law. However, they are not part of a system of binding precedent as in common law jurisdictions. Generally, in practice, however, international courts and tribunals are very reluctant to change legal principles established in earlier cases, and as a consequence, they are a significant aspect of your international legal research. So when conducting Research, it's important to locate the official collections of international law reports, as they form a permanent record of these court decisions. So that kind of takes us to the conclusion of the first module, Sources of International Law General Introduction. We've looked at types of international law, sources of international law, and some of the terminology used. The next module will cover secondary sources that will assist you with your international law research. If you need any help, please don't hesitate to contact the Law Library. There's some of our details on the slide. We're always happy to hear from you and do what we can to assist you with your legal research. Thank you.